What's up, guys? So we have another document dropping in the lull suit. And for those of you following and listening at home, the lull suit is Maddox versus Dick Masterson in an epic showdown, the winner of which, well, not really, but the accusation is that Dick owes Maddox $20 million, which is something that no one could possibly cost Maddox, even if Maddox lived to be 370 years old. He just would never, ever have a brand worth that much money. But nonetheless, again, probably due to a drafting error, Maddox, has actually sort of probably on accident sued for over $300 million. I don't know. I don't even care. At this point, why bother caring to figure out what he was trying to do? And let's just go with the funniest. And that is $500 million in lawsuit damages have been requested. And when you're writing a lawsuit, right, there are things that you do. There are things that you do to strategically position yourself for the best outcome. Like, for example, if there are favorable federal rules to state rules, and the threshold in federal court is a claim in excess of $75,000, then what you do is kind of no matter what the damages are, since you don't usually know, right? Like a lot of these claims, you don't know what the total damages are. You may have a guess, but you don't know what the judge or the jury is going to decide that the damages will be. So what you do is you make your claim in excess of $75,000, and you leave it at that because that satisfies the threshold for federal court. And then, then if maybe they only award you $20,000 because that's all your claim is worth in the eyes of a judge or a jury. Okay, fine, but you got it in federal court, and that's where the favorable statutes were, and you could reasonably determine that a judge might give you $75,000. For example, if you're like a California lawyer or a California plaintiff and you're suing a New York defendant, you can maybe sue New York defendant in federal court for in excess of $75,000, maybe, and you might then have a claim. But if you're suing under New York state law, you have different thresholds that you're looking at, and one of them, if you're in the New York County law system, one of those thresholds is $500,000. And if you sue in excess of $500,000, and at least some of your claims, or at least the nexus of events that have caused those claims are commercial in nature, like, say, fraudulent misrepresentation or violations of the New York business laws, then if you have those and you're over $500,000, then your lawsuit might just belong in the the New York Commercial Division. Okay? It might. It might not. And you certainly might not want it there. Like if you're trying to drag out a lawsuit and bleed people out of money and be a total pansy, you probably don't want it in the Commercial Division. Because the Commercial Division is where lawsuits get fast-tracked to resolution by sophisticated parties asking for tons of money and actually having prepared for the lawsuit that they've decided to pursue. It's not for people who hire lawyers who don't seem to have any interest in the case. It's not for people who draft their own documents and have a lawyer sign off on them. It's not really even for people who don't understand what an apostrophe is. It's for people who are kind of on top of the lawsuit game. But nonetheless, we have a lawsuit that is well in excess of $500,000, even though no reasonable human being would think that any of the conduct, even if taken as true and illegal, which is a big leap, but even if everything is true and everything is a violation of the law, no one on earth would think that Maddox was damaged to the tune of $500,000. Not a single sane person believes that that much damage was caused. Not a chance. Not a chance. Like, I can't even stress enough like how ludicrous it is to think that he would consider these damages in excess of $500,000. I mean, maybe 50. Maybe 50. But Maddox, your brand is still successful, right? Like that's the line. What was it? Someone told me that you had plenty of money to do all of this, and that your business was doing great, and your fan base was still huge. So if that's the case, you could not have lost $20 million. Like, you could not have lost that income opportunity because you're still making mad bucks, right? You're still doing that. You're still raking in the cash. So I think tonight is I still have a little bit of this Balmore 18 left. It's really running low, which is a shame. But I have other whiskey on the way. I have other whiskey on the shelf. I have reserves, we'll say. But there it goes. I can hear Celine Dion singing now. The Titanic has sunk. But, excuse me. Let me just take a little nip of this. All right. Where was I? Okay, yes. According to Maddox and all of his public statements and the statements of his fans about this, he's doing just fine. So it's interesting that he would suggest that he's lost $20 million of income if he's doing just fine. And I know it doesn't directly translate to income loss. Like, there's some other stuff that he's saying, but like, let's be realistic. Like, let's say that Dick single-handedly destroyed Maddox's book sales. What's he cost him? What were his expected book sales going to bring in? Like, honestly, you haven't written a book in a decade. Your last book did not do well. This book was not poised to be a New York Times bestseller by any stretch. You're out of the zeitgeist. Even if you would come up with all new material, your material isn't fresh anymore. Like, what you do is done by tons of other people. Like, making fun of people on the internet is just what Facebook is now. So I'm not sure the President of the United States does a better job of trolling people online than you do. So no matter what your book was going to be before you decided to not write it and to just throw a bunch of old articles in it, it was never going to be a breakaway hit. It just wasn't. Your novelty expired a decade ago. And I thought, I'll admit again that I have enjoyed some of your YouTube videos, not, obviously not recently, but a couple years back, like your Spider-Man, your Spider-Woman YouTube video, the one about Facebook and all the promotion that people do and stuff, and the life hack one. Those are funny, man. They were good. I mean, they weren't like change my life funny, but they were funny enough. But yeah, you need to you need to figure something out, because it's not like serious talk show host. You're not Larry King. And I don't think anybody's looking for another Larry King. At least no one in your fan demographic. So I don't know what it is, buddy, and you don't either. Why am I ranting to you? I mean, other than I know you'll see this, so that's slightly heartening. But let's go through this, okay? And I've gotten a couple questions on this. And by I've gotten a couple questions on this, I have seen questions posted. Not all of them are directed at me. And so I don't want to, sound like people are calling me off the hook here and demanding that I answer these important questions. But I'm going to try and address some of the questions I've seen, some of the main kind of themes as we go. But first, let's just go through. This is a pretty short little order here, and it should not take long. All right. By letters dated January 12th, 2018, Counsel for Defendants CMGRP, doing business as Weber Shanwick and Joshua Kaufman, together with Counsel for Defendants Patreon Inc. and Jordan Cope, timely request. This means that they requested it within 90 days of service, because that's the time limit for this. Timely request that this action be assigned to the Commercial Division. No response to the letter request has been received. Now, I don't know. Like, it's not like they'd have much grounds to object to this. But maybe they should have tried to object to this. And it's preferential, but it's a good idea to object to a lot of what your opponents do, because a lot of what your opponents do is in their favor. So you might want to throw up an objection, even if you don't think it's the right, or not the right, even if you don't think you can win the objection, you might want to throw it up because you might win it. But no response to the letter request has been received. We don't know why. Maybe Landau just didn't oppose it. Maybe Landau's worried about billing Maddox, because maybe Landau's worried about getting paid for the work that he does. I don't know. We'll see. I guess it would depend on if Landau is getting paid for the work he has done. And, Landau, by the way, if you see this, Maddox and his fans have both suggested that the show is very successful and he's making tons of money. So if he says he can't pay you, maybe he's lying. That's interesting. So we go on. Actions in which the principal claims are for breach of contract or business torts. Breach of contract or business torts. Where the breach or violation is alleged to arise out of business dealings may be heard in the Commercial Division, provided the $500,000 monetary threshold for New York County is met, or equitable or declaratory relief is sought. Now, see, this is interesting because this doesn't arise from a breach of contract. There's no alleged breach of contract. There's kind of an alleged breach of contract, but not between any of these parties. When they say that some of the claims were tortious interference with a contract, right? So the idea would be that someone breached a contract, but they didn't actually plead to the fact that someone breached a contract. And I don't think anybody did, but this is over the sponsorships, right? But that doesn't count. Like, there's a breach of contract that occurred, allegedly could have occurred there, but that doesn't actually count. What they're talking about is a breach of contract between the two parties, or business torts. The specific commercial code violations that they brought up earlier. So the interesting thing would have been to argue that there was no breach of contract and there are no business torts, because what they are actually, maybe they would even admit that they were wrong in those counts of law. I don't know, to try and keep it out of the Commercial Division. Arguments could have been made. They can't be made anymore. But let's see. In this action, Plaintiffs allege that after the conclusion of a successful 2-year internet podcast venture between plaintiff George Uzunian and defendant Dax Herrera, in conjunction with the other defendants, engaged in cyber mob attacks and numerous other online harassment campaigns directed at Uzunian and his girlfriend, plaintiff Jessica Irene Blum. The complaint asserts various causes of action, seeking $20 million in damages for the defendant's alleged improper and tortious conduct. So, the New York clerks have read it as $20 million, and I think, honestly, I think that's the appropriate amount. But again, $500 million is funnier. And incompetence makes things even better. Among other claims, the complaint purports to allege causes of action for invasion of privacy, violation of Civil Rights Law 50 and 51, defamation per se, unfair and deceptive trade practices, unfair competition, those two are your big business ones, right? Intentional and negligent infliction of emotional distress, tortious interference with contract and business relationship, conversion, false advertising. In violation of General Business Law 349 and 350, those are your other business transactions, and fraud. Plaintiffs allege that the defendant's conduct, in addition to being wanton and vindictive, has, quote, created a thriving business around their continued harassment campaigns, cyber mob attacks, and threats against plaintiffs. The request is granted since the allegations of the complaint meet the requirements for assignment to the commercial division. The General Clerk's Office is directed to randomly reassign this action to a justice of the Commercial Division. Motions to dismiss the complaint are currently returnable in the e-filed submissions part on February 16th, 2018 and February 27th, 2018. And this is checked as a non-final disposition. This just means that the case remains open after this order is in effect. And it is signed by Deborah Kaplan, who is an administrative judge. Okay, so the first question to get out of the way is this closing paragraph here. Someone asked if these lines, what did they say? Hold on, I'll pull up the question on my phone, because magic. They asked if jokes about doom. Where did it go? Man, I'm terrible. Oh, okay, so the question was, last few lines of the doc sounds like he might be able to request dismissal of the suit if he does so before February 16th. No, that's not what the last line's about here. What they're talking about is that the submissions filed by some of the parties suggest that the return date, or the date on which the motion to dismiss in specific this is for Weber Shadway. No. Oh my goodness. This is for Kokonos. Kokonos' motion to dismiss has a return date of February 16th. So that's the date that motion to dismiss should be heard. And if we remember, it's from this document. This is the stipulation of Kokonos, between Kokonos and Maddox, or well, between Greenberger and Landau. So it's this first paragraph here that's the important part. It is hereby stipulated and agreed by and between the undersigned that the current scheduled return date of January 26, 2018 for defendant Asterios Kokonos motion to dismiss plaintiff's complaint be adjourned to February 16th, 2018. It is further stipulated that the time for plaintiff's response, and this is what we care about, or what I care about, because this is when I get to do funny videos, and I thought I had a couple more days. The time for the plaintiffs to respond to the Kokonos motion to dismiss is hereby extended to and including February 5th. February. There's an R in there. February 5th, 2018. So by February 5th, we will have a response from Landau, or we should, if he's still even paying attention to this case, we'll have a response from Landau. And if we don't, it'll be very likely that the judge, especially a commercial division judge, if they don't respond, will dismiss the claims against Kokonos. That will happen if Landau does not respond by February 5th. So if Landau does respond by February 5th, Then Kokonos through Greenberger can reply. Greenberger? Greenberger, not Greenberger. Greenberger's a rotten piece of beef. Greenberger is a lawyer. Greenberger can extend and include until February 15th. So he gets another 10 days to respond to the response. Pretty typical. Nothing special there on those times. So that's the next document we should have in, well, by now, I'm recording this on February 2nd in the morning, so 3 days. We'll see. We'll see what Landau's got cooking. Oh my goodness. So that's what they're talking about here. They're letting the court know that they need to assign someone, and they need to do it quickly, and also address this return date. Now, I'm not positive because I don't practice in New York, right? So I can't say for sure, but I would think that if they move this to the commercial division and there's just no judge with time on the 16th, that date may get moved. They may get a continuance on that hearing date, and it just may not occur on the 16th. It may. Maybe that's part of the thing with the commercial division. Like, the whole point of it is efficiency and execution, and not having these cases drag out and cost everybody tons of money and take forever. Because if damage is being done to a business, they want that rectified, and they want the business to go ahead and get back to doing what they do. They don't want them lolling around in court doing nothing. So they should be trying as hard as they can to preserve this February 16th date, but I don't want to say it's set in stone. That is very quickly, if they're moving it as of yesterday or today, they're moving it to a new judge in the commercial division for them to hear in 14 days is pretty quick. But that's what it's there for, so maybe they will. The other one is February 27th, 2016. That would be the... let's see. Oh, wait a minute. Oh, okay. Yeah, February 27th. That is the February 27th is Dick's response to Dick's motion to dismiss. Was done here. It is hereby stipulated and agreed by and between the undersigned that the currently scheduled return date of January 30th for defendant's motion to dismiss plaintiff's complaint is hereby adjourned to February 27th. So we'll get a document on February 12th from Landau on that one. Oh, excuse me. Patreon has extended to March 9th for the next date. Let's see. Oh, no. February 23rd. And then Patreon and Cope will respond by March 9th to whatever comes in on February 23rd. And then March 9th would be their return date. And then finally, Weber Shandwick is the last group. They have not currently, as far as I have seen, they have not actually extended the time, although they had the latest time available. And that was February 23rd is when Landau has to respond to them. And then their reply will come by March 13th. So, that's where we stand right now. So no, the Maddox cannot dismiss the suit by requesting it before February 16th. Although it is, at any time, a plaintiff can petition the court and request, a plaintiff can petition and request the court to drop the case due to all sorts of things. There are rules on when you can drop a case and when it becomes too late, but they could request it at any point still and just say, no, we were so hilariously wrong that we should not be doing that. But they have not done that yet. And at this point, If they do, like, we're at the point now where if they just decided to drop it, it would probably be dropped with prejudice, but they may save themselves some attorney's fees. So it might be good if they did that. Another question was, can this case still be dismissed for improper jurisdiction? Or is that no longer a possibility? No, that is still a possibility. It is every motion is still in full effect. They will just now be heard by a commercial division judge rather than a regular civil judge in New York. So again, these are the people who deal with these commercial matters on a frequent basis. The court is much more no nonsense. It moves much quicker, and the requirements for the parties to be active, involved, and knowledgeable of everything go way up. So you don't get to request like 25 continuances. You don't get to show up to court and be like, oh, I'm not really prepared for this argument. You don't get any of that. That doesn't happen anymore. At this point, it's game time, or you lose. That's how it goes. So yes, improper jurisdiction still on the table. Still a likely outcome, actually. How much is Maddox doomed now, or is this transfer not set in stone yet? Very doomed. The case was a stinker from the get-go, but now that it's in the commercial division, the ultimate reality is that, again, they deal with this stuff frequently. They see frivolous lawsuits frequently. People think that you can just sue big companies and that the companies will settle, and some of them will. Uh-oh. Holy cats. Sorry, I sneezed, and with the size of my nose, that's a dangerous thing. Sometimes suing a big company will result in a quick settlement to make you go away, because sometimes it costs big companies more to pay their lawyer team or a legal team to go out and fight this stuff. So sometimes you can get a settlement, and I think that may be what Maddox is looking for here in bringing in Weber Shandwick and Patreon, that they might just pay for this to go away. He'd get some money, and everybody would be happy. But no. The commercial division is more trained to spot these type of things, and they are quicker to dole out some retributive justice to frivolous complainers. Let's see. Do we have any other questions? Not really. That's the ultimate gist of what we've got going on here. All the dates are still the same. This is at the moment. They could be assigned to a judge who does not have the dates available. Again, in my experience in Minnesota, which does not have this type of process, getting reassigned to a new judge and having them have availability within 2 weeks is not a thing that happens where I am. Where I am, judge availability goes way out. So I don't know if this is a thing that they will do. I wish I had a better answer. I hope so. But the deadlines on the motion responses should still remain the same, even if the date gets changed on the final return dates for these things. So if they don't have this February 16th deadline, I think we still have the February 5th deadline for Landau's stuff. That would be, unless we get an order from a judge stating otherwise, that should be the outcome. But, I don't know, man. We're going to have another video in a couple days here. So I'm actually going to wrap this one up. We're right about at 30 minutes here, and I think that is plenty of time. I could probably rant on about something, but this is a great, we'll put it this way. This is great for all of the defendants. This is terrible for Maddox. This is not where he wants to be. it goes to show the problem with a lack of planning from the onset, and maybe a lack of involvement from his attorney. I don't want to cast aspersions because I don't know, but maybe his attorney should have advised him otherwise, but maybe he isn't paying his attorney enough to make that sort of advisement. I don't know. Either way, you two make a terrible couple. That would be Maddox and Landau. Whatever thing you've got going on is destructive for both of you, and you should get out. You should get out of it as soon as possible. Because however you've got this arranged, it's not going well. So anyway, we'll see what happens. I am waiting with bated breath, as I know many of you are as well. I'm going to wrap this up now. Thanks for watching. I hope you guys are enjoying this drama as much as I am. I cannot wait for the responses. If they're of the caliber that I think they may be, I might be live streaming every single response that comes in. Because they're going to be a lot of pages, and they're going to be funny. If nothing else, I think they're going to be hilarious. So, keep a watch out for those on my Patreon page, on Facebook, on Twitter, wherever. Keep a watch. If you don't know where to find out the info on this stuff, just find me on Twitter. All of this junk is linked in the description, so find me and send me a message somewhere, and I'll try and respond. Reddit is I stopped getting notifications in my email for Reddit. I don't know why, and I'm really bad at using it. So that's a hard place to send me a message. Shoot me a message on Facebook. Shoot me a message on Twitter, something like that. I will see those. Go on. Don't shoot me a message on Gab or Minds, because those don't have a good notification system either. Or I'm bad at using it. One of those two. Best place to find me, Facebook. Just shoot me a message if you're looking for when this stuff is coming out. And like I said, it should be the 5th. If it's the 5th, I'm going to live stream them hopefully the night that they drop. Okay? Unless something really weird happens. But it should be a blast. The live streams on these things will be public live streams. And bring your questions to the live stream, and I'll try and keep up. But we're probably just going to have a fun time reading through the brilliantly crafted responses. And maybe we'll be shocked by what comes out. But I think we're just going to enjoy a lot of drinking and a lot of laughing. And I can't wait. I'm really looking forward to that next week to start. But anyway, thanks for watching. Peace.